discrimination very closely. So, for example, the Convention of Elimination of All Forms of Discrimination Against Women has a definition of discrimination that I discussed yesterday. The Convention on Elimination of Racial Discrimination, CERD, has uh, uh, discussion and in its committees on discrimination. There are many international bodies that have discussed the question of discrimination. International jurisdictions have also discussed, yet we will be guided by what our constitution says and by and large by what our constitutional judgments have dealt with. Now, if you look at Article 15, now let's look at Article 15 a little more closely. Is it helpful for you if I share my screen on Article 15, or do each of you have a copy of the Constitution in front of you? It really depends. If you want, then I can share it. Is that helpful? Or do you all have it in front of you?
I suppose everyone has the copy.
Everybody has the copy? Fine. Good. Now, look at Article 15. It says, reading 15.1, the state shall not discriminate. We've been into that. That is the vertical that we're looking at, not so much horizontal. State shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Now, place of birth. Look at this. Religion. On the ground of religion, you are not supposed to discriminate against any citizen on the grounds only of religion. On the ground only of religion, that is solely on the ground of religion, you should not discriminate. On the ground only of race. Now, race is a category which is there in our constitution. It was put in during our debates, but with hardly any discussion, because racial discrimination was seen as something that in India we are not expected to have, because race was somehow seen in terms of white and black. And so while the Americans could have had racial discrimination with slaves, then later on, after they became citizens, black and white, it was not so much expected in India. But I think in the last 10 years, the fact that there has been so much discrimination against people from the Northeast, and much of it has also taken racial overtones, indicates that that word race in Article 15 definitely would develop in the years to come. To the best of my mind, while the Northeastern groups have alleged that there has been racial discrimination, I've not yet come across any judgment of the High Court or Supreme Court at that level. It could be at the level of the police complaints that there are there, but this is something that I see may happen. When the World Conference on Racial Discrimination took place about 20 years ago at Durban, South Africa, there was some attempt by some of the groups in India to treat caste discrimination as a form of racial discrimination. But somehow it was not considered appropriate, not from any diplomatic point of view, but even from a scientific point of view, because we do not have any kind of either data, or do we have any sociological or anthropological studies to show that there are caste or tribes constitute separate races? And this has been a subject matter of study for anthropologists and sociologists. So I'm not really going into it. I don't think I am at all equipped, but I'm alerting you to a very high profile discussion that took place in India about 20 years ago, whether the category of race would also include castes are treated as race. But historically in India, at least legally speaking, we have never treated tribes and castes as different racial groups. They could be different caste groups, different tribal groups, but certainly never different racial groups. And I don't think I have anything further to say on this point except to tell you that such a discussion historically has happened. And a large number of leading sociologists in India also jumped into the fray. Our own Professor Andre Bete at that time was still working in Delhi School of Economics. He also weighed in, and there was a large number of, people who, sociologists and anthropologists who spoke about it, and this has been there. So I think for the moment, that's all that I wish to say about race, about the Northeastern issue, and whether there is a complete overlap between caste and tribe and race, which was rejected and never was accepted even in the World Conference of Racial Discrimination, which is part of this annual, every 5 years on the CERT Convention against for the elimination of racial discrimination. Shall not discriminate on the grounds only of caste. Okay, thanks, Praveen. Sukanya, is it? Okay. On the grounds only of sex, on the ground only of place of birth. Now, this word place of birth is again an area where in the 50s and 60s there was more court cases than there are now, because I think some amount of the matter has been settled. And the question is that if you look between Article 15.1 and just glance at Article 16.2, I have lots more to say about 15, but for the moment, I want you to compare three articles: 15.1, 16.2, and 29.2. These are three non-discrimination provisions that you see in our fundamental rights part. Now, if you look at the grounds in 15.1, states shall not discriminate only, I'm not yet coming to what is the jurisprudence of only, religion, race, caste, sex, place of birth, or any of them. Now, that word any of them would mean that you could either have all one or two or three or four or five all combined. So there is or any of them. So meaning instead of it all combined, it could be even head by head. Okay. But when you come now to 16.2, look at 16.2. No citizen shall on the ground only. Okay, so it begins somewhat similarly. On the ground of religion, race, caste, sex. So these four are common: religion, race, caste, sex. Then we introduce a new one called descent. And then we go back to place of birth. And then we have another new one called residence, or any of them shall be ineligible for or discriminated against with respect to any employment or office by the state. So this kind of discrimination and the prohibition against discrimination is rather broader for citizens, because we have two new grounds here: descent as well as residence. And it says this discrimination is confined to discrimination vis-a-vis public employment and to be eligible for an office. Okay. And what's the difference between employment and office? Employment is joining the government as an employee and being governed by any of the rules under which you have been recruited. But if when we come to part 14 of the Constitution and we look at services under the state, that part of the Constitution, and I'm now talking about Article 309, 310, and 311. I don't know whether we will ever have time to teach it. It's there in the syllabus, but by the time we come to the amendment, there's such an overload on students truly that we are usually very reluctant to teach it, because there's just too much pressure. When you come towards the exam, you'll realize that this is a vast course. Okay. Now, what is the difference between an employment and an office? Office is holding a position which is not part of a cadre, and which is not part of, which doesn't have any progression or any promotion where you are part of a cadre. So, for example, joining the IAS or joining the civil services would all be forms of employment. But becoming, say, the Comptroller General of India or becoming a member of the UPC would be an office. And neither for joining an office of that nature or for joining employment, there is a ban on discriminating anybody. Here, you will notice that religion, race, caste, sex, place of birth is there, but descent and residence has also been added. Okay. So we have 1, 2, 3, 4, 5 in 15.1, and we have 1, 2, 3, 4, 5, 6, 7 in 16.2. Now, just because I'm wanting to do it so that you can see why that 16.2 is broader than 15.1, is there a reason? That's the question that I'm asking you. So as I'm talking, please think about it. Now come to 29. 29 is dealing with cultural and educational rights. And there again, there is a non-discrimination which the state should not do. And once again, against the citizens. So the parties are the same. Citizens on the one hand, state on the other. But here we're talking about education. And now look at 29.2. No citizen shall be denied admission into any educational institution maintained by the state. It could be either fully funded or partly funded. The word maintained, there's enough case law on that point, or receiving aid out of state funds on the grounds only. And look at this: religion, race, caste. We've dropped sex, we've dropped place of birth, but we've added a new one called language. Okay. Now, so I placed before you 3 kinds of anti-discrimination provisions in front of you. 15.1, 16.2, which is more focused. 15 is the broadest. On any front, it can be on getting medical treatment, it can be on applying for a loan from a government bank, it could be on getting admission, it could be on, making use of our services that the government offers us, like the railways, blah, blah, blah. Anything, that's 15.1, it's broadest. 16.2 is for employment in offices, 29 is specifically for education, getting admission. Now, the bases of discrimination are different. I would like just to spend a minute or two to hear your responses, why there is differences in these 3. Obviously, it's a function of what that article is dealing with. But why is there a difference between 15.1, 16.2, and 29.2? Anybody, just take a political guess. Yes, turn your mics on and speak, please.
Ma'am, with respect to 29, it is to protect the linguistic minorities, and with 16.2, the word residence is to prevent the son of soil policy in public employment.
Good, I accept both of them, but are there any more reasons? Yes. So, Yogendra, just elaborate, why does 29.2, by putting language, how does it protect linguistic minorities? Because those minorities will not get any special benefit. It says state shall not discriminate on the grounds of language.
But it prevent their exclusion as well. So if they not, means it is not affirmative, but it is discriminatory.
Okay, that's a good important point. But is there any other explanation anybody else has for differences and any other things? Why, for example, has sex been dropped? Why has place of birth been dropped? Why has residence been dropped? 29.2. Yeah, Yogendra or anybody else? Let's take up 29.2 since that's under discussion. Yes, Yogendra. Would anybody else?
No, I don't.
Yeah, okay, fine. Thanks for that. Yeah. Who was speaking here? I heard a.
Ma'am, probably because those are not important parameters because of which the education right can be denied. But the ones that are mentioned, they could be something because of which the education rights to an institute or something can be denied.
So sex is not an important ground. You can deny a woman
No, it could be like in the 19th or 18th century, but not as of now because of equality that are given to both women and men for education and other things.
So then why didn't they put sex?
Ma'am, so that they can form different colleges for girls and for men.
Yes, that's true. So if we had only a government run women's college, then obviously you would be discriminating against men for entry into that college. And therefore, had we put sex as a ground in 29 too, it would have been a problem. So that explains why sex is dropped. Okay. But why language has been added, Yogendra has given one reason, which is yes, it's a negative explanation for why language is there. Does anybody else have any other opinion to share with us?
Because based on the regions, they'll have their own set of like the official language, and they can set up.
No, if that was so, then language should not be there. Na? Suppose I set up a language in a tribal district in Madhya Pradesh, okay? And I would like Gond speaking students to come in. Then by putting the word language, it is possible that Hindi speaking people can overrun and take all the seats. Whereas I've specifically opened it for people in the Gond language. Then by see the explanation that we had for dropping sex is because we knew we would want to have only women only colleges. Then all the men would go and say, why aren't we being admitted? By that logic, if it is to protect the language, would the protection not have been served better by not having language as a ground of discrimination, is my question.
Now, it's according to me, in my opinion, it's not so much as to protect the language than to protect the speakers of the language from joining an institution. Because in India, especially, there are a lot of dialects, and maybe someone who speaks a certain sort of language does not have the same dialect as someone else who speaks the same language. Okay. And so maybe discriminating against a language can be super elitist, or can also be in some ways tied to caste, because upper castes have a different sort of language and lower castes.
Okay, but let me now introduce a point to you. When the discussion word language is discussed and the way language is interpreted flows from 29.1, we're not looking at dialects at all. They all fall within the mother language. Okay, so while you know that technically the whole North India is a Hindi speaking belt, you know and I know that if we went and listened to somebody in speaking generally they're all speaking khadi boli type of Hindi, but if we went and listened to Bhojpuri or Haryani, honestly, I cannot understand at all. So technically, they all are supposed to be Hindi speakers, right? So whatever the variant, you're all supposed to be. So if you go to Rajasthani, okay, it's quite distinct. Bhojpuri now, of course, come into its own and it's in the 8th schedule, but before that, yes. Okay, so just keep thinking about it. If you have a view to do, tell me. Otherwise, I'm moving on to Article 16 and why there is the addition of place of birth, residence and descent. Yes, somebody was saying something, please.
Yes, ma'am. I consider inclusion of language in 29 to is more of a political reason, ma'am. Considering the Dravidian movement which took place pre-independence by Periyar. So to consider the people coming from south and to meet their consideration, I think the language was included so that they could not be discriminated. So it has a political overtone more as we compare to 15, because 15 is much more broader as compared to 29.
You know, it sounds very attractive, but it's not borne out by the Constituent Assembly debates, would be my initial answer. You are very right. If you take the amount of time that was spent in deciding the section on language, okay, you know, if you look at Article 350, 50A, 50B, 51, 52, these are the parts of the Constitution dealing with language. We spent more time discussing the provisions dealing with language than we discussed anything else. So if you were to put a timeline to the draft constitution and its adoption, it took virtually almost 11 months to draft constitution. Started discussion around February and it finally got voted upon only in November. And Granville Austin makes the point that the one that took the longest time was the language. Okay, that is, I'm now talking about part 17 of the Constitution, official language. But the debate there primarily took about whether we should have an official language or not. Okay, so the discussion on 29.2 didn't take that much time. If you look at the way in which the debates went, and which is why I tell you that as law students, the luxury that you have now, you will never have once you start practicing or you take up a job. Okay, and the luxury of being a student is wonderful because you have the time to read. But if you look at it, you will find that the debate on this part of the Constitution went exceedingly fast. Tuck, 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 it went. Yes, somebody has its hand up.
Yes, ma'am. This is Praveen, ma'am.
Yeah, Praveen.
Ma'am, can we see this into the historical aspect as consolidation of India as a nation state? Since from the beginning, the important point to be decided upon was the status and the rights of these minorities in their states. On the one hand, there was the question of their protection, for there was the ever-present danger of them being meted out unfair treatment. On the other hand, there was the need to promote their integration with the major language group of state.
Yeah, but therefore, I mean, it's all very nice and interesting. What you think. Therefore, no, just one moment. I just want to push Praveen a little more. Therefore, on 29.2, you haven't concluded. You made a point, but it's not concluding my question. Therefore,
yes, sir. A linguistic minority had to be given the confidence that it won't be discriminated against by the majority, and that its language and culture
that Yogendra was saying right at the beginning, that we are using it more from a defensive point of view, that you will not be prevented. And I think even the other person who was speaking about Dravidian was making that same point. Okay, fine. I mean, there's no hard and fast answer. It's not that I have a magical answer that you don't have, but it is merits discussion. So we could look at the introduction of language as a prohibited ground of discrimination to say that nobody will be denied admission merely because. And if you remember last semester, we did a case called Gujarat University was Sri Krishna Madholkar. Do you remember?
Yes, ma'am, on higher education.
Now, here is a student, say, who comes from an English medium or Hindi medium, and he wants to get admission to an English medium college. So in law faculty, for example, we never ask you what was your medium of instruction in your undergraduate or postgraduate. We don't ask. We only ask, did you get sufficient marks in our entrance test? It does not matter to us whether right through you studied in Hindi medium or not, because while our classes are in English, we think that anybody should have a right to come and enter. And then, of course, while you're studying here, you can write your exam in Hindi, but the classes are broadly conducted in English and you will make do. So it doesn't really matter whether English is your medium of instruction. So to prevent discrimination from people coming from other mother tongues other than that which is being offered as the medium of instruction or the medium of examination by that college. Fine. Now let's move to 16. Okay. And the elimination of sex also we looked at. We've still not come to a decision on why place of birth was also dropped in Article 29.2, even though in its broadest avatar, which is Article 15, it is there. But there's a general proposition of law that for a specific purpose, if there's a specific provision, it will exclude the more general provision. So when it comes to admission to colleges, the specific provision which is in 29.2 will exclude the more general and universal provision which is in Article 15.1. Okay. Specialibus non-derogant. That's one. Okay. Now let's come to 16.2. Here we are dealing with employment, and we see two new words that are added, which is residence and descent. So, what's your theory for inclusion of? Somebody already mentioned sons of the soil. I forgot who it was. Can that? Yeah. Why have we got a new ground of discrimination, which is residence? Come, this you must have a theory for.
Oh, ma'am, is it because of section? Sorry, ma'am. Is it because of Article 19 to reside and settle in any part of territory of India? I mean,
Right,
can we
that is
correct?
part of the answer. Yes, good. And then, why has it been a prohibited ground of discrimination? Therefore, push your argument a little further. Therefore, Anamika.
Ma'am, I'm trying to.
Okay. Anybody else?
I mean, also integration.
Okay, who is this person speaking?
Vishal, ma'am.
No, Vishal, that all, its effect is different. The reason for its inclusion, I'm asking. Reason for the inclusion of residents. I think Anamika has it. The other person who spoke on the sons of the soil also has it.
Ma'am,
Hmm.
and also actually the public employee.
I heard public employment, then I didn't hear anything else. Yes. Look, for example, many of you are going to be writing the judiciary exam, okay? Now, for the judiciary exam, you may be, let's say, living in Uttar Pradesh, currently now living in Delhi. As a Delhi wala oblique Uttar Pradesh wala ya wali, can you appear for the judiciary exam in Maharashtra?
Yes,
Yes, you can. Which means that on the ground of residence for public employment, because after all that is employment, right? Judicial services, you cannot have. So the person, the sons of the soil, which is a slogan that jobs by that local government should be reserved only for people who are resident there, has been a very, very strong, sort of part of the political discourse in India, and therefore the constitution makers wanted to guard against it, because we have one India and anybody should be free to apply for jobs in any part of India, irrespective of where. So, like Anamika mentioned, 19, that everybody has freedom to reside anywhere in India. Look at that article. Look at Article 301, that you have the freedom to do trade and commerce and intercourse anywhere in India. So, as a market, we are one. As a place to travel and settle down, by and large, we are one. Then it should be one market, even in terms of labor markets. And therefore, 16.2 said residence should not be a ground for discrimination on grounds of. Okay. Now, place of birth. Place of birth, is it different from residence? Is there a difference between place of birth and residence?
Ma'am, would it be like place of birth would be domicile of origin, but the residence would be domicile of choice?
It would be something like that, but we don't normally borrow those two terms from private international law when we are looking at constitution. But since you've raised it, let me just address it. Domicile is not a consideration when we are looking at these articles, because domicile has two elements in it. It has a factum element and it has an animus element. So in private international law, the question whether I'm a domicile of X country or Y country is dependent not only upon whether I'm living there, but whether I have the intention of permanently living there. So somebody who has come on a holiday to another country could still claim that I am a domicile of some other country because my intention is there. So the intention sort of is a very important factor for deciding questions of domicile. Whereas in residence, it's not whether you intend to be there. So if you look at admission criteria, and please note, residence is not a ground of not a prohibited ground for discrimination in 29, which is why in educational institutions you can have a what we loosely call a domicile quota. So take Delhi University for example. It's a central university. We do not have any domicile quota at all. Yet in another university right here in Delhi, which is the Delhi Government's University, the Guru Gobind Singh IP University. It is a Delhi government funded university, and 85% of seats are reserved for people residing in Delhi. And the test of residence is purely factual. Did you study your 11th and 12th class here? Have you resided here for 4 years before, or have your parents lived here for 4 years? Just a factual question. There's no animus question at all. Do you intend to make Delhi your permanent home? Those questions never come into it. So it's for that reason that the word domicile was never used here. So you're right. So now you can see why residence is put in as a prohibited ground for discrimination for employment. But residence is not included when it comes to admission in Article 29.2 because educational institutions being run by different governments, including state governments, should be able to reserve some of their seats for people within their domicile. Okay, what we're calling domicile, but actually a preferable word would be residence. Okay, right. Now, place of birth. The place of birth doesn't really matter where, but one of the reasons why place of birth, in my opinion, was put in, it's slightly different from residence because I was born years and years ago, but how does it matter? Where I am currently, for the best of my life, I have lived in Delhi, right? So, maximum years, I'm a Delhi person. So now, that place of birth is there. Now, place of birth was definitely added because during partition, so many people were going to cross, and many people in current day India would have had their place of birth in Pakistan. And normally, for citizenship, there is a domicile by birth. And normally, in many countries, if you are born in a country, you're entitled to citizenship. Now, we've not taught the provisions dealing with citizenship, but if you look at citizenship, if you look at Article 5, just for a moment, just go back to Article 5 very quickly. Look at the word domicile is used here. Okay? It's not used in Article 15 or 16. Now, look here. Every person who has his domicile in the territory of India, that is, has intended to make India his or her long-term home, and who was born in the territory of India, or either of whose parents was born in the territory of India, or who has been ordinarily resident for at least 5 years previously, would be entitled to citizenship. But because that Article 5 allows you to claim Indian citizenship even if you were born outside, because birth in India is only the first limb of the test. The other is either of whose parents were born in India, or the third limb of the test has nothing to do with birth but is only to do with residence, 5 years. Okay, so on the ground that you were born, let's say, in some other country, that should not be a ground for discriminating against you because you can become a citizen even if you were not born in India. And remember that the partition times, put your mind back to how it was 70 odd years ago, and it comes as no surprise then that the Constituent Assembly felt that since citizenship is linked under Article 5 to ever so many grounds There are so many feeder channels, if I could put it that way, to become a citizen. There's a place of birth is there. So there's a separate place of birth and there's a separate residence when it comes to Article 16. So Article 16 really was going to go against the son of the soil. But since I'm now here, let me just make one small point about Article 16 again, and that is Article 16.3. 16.3 permits central parliament by law to provide for local sons of the soil reservation. You look at 16.3. Nothing in this article shall prevent parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office any requirement as to residence within that state. So domicile reservation in employment is permissible, but not to be done by the local state government, which will be full of its sons of the soil politics and rhetoric, but is to be done by a cooler mind, which is little more detached, which is Parliament of India. Have there been such laws made? My answer is yes. If you look at Hyderabad, one of the conditions of Hyderabad acceding to the Indian Union in 1949, remember that Hyderabad was one of the last princely states to accede to India. One was, of course, Kashmir, and then there was Kathiawar. There were a few that came later in 49. Manipur was one.
Junagadh.
Sorry?
Junagadh.
Yes, Junagadh came late and Hyderabad also came late. And one of the negotiations when it was happening on Hyderabad was the need to have, and eventually these were adopted by Parliament, what are known as the Mulki rules. Okay, Aap kis mulk ke hain? The reason is, and there's a historical reason for it. So let me deal with it. Normally I'd have told you the story in 16, but now that I'm here, let me finish it off here. That is, you see, the Nizam of Hyderabad was historically a person who came from the courts in Lucknow. Okay, from there. And because the Nizam's family came from there, and I'm talking about hundreds of years before, okay, I'm not talking about the last Nizam of Hyderabad. A lot of people from Lucknow came and started residing in Hyderabad. And these were all Hindi speakers, they were Urdu speakers. And the question would be, what would happen to lakhs of people who had come over hundreds of years and settled in Hyderabad, because there was every possibility that once Hyderabad joined the Indian Union and became Andhra Pradesh, that Telugu would become the official language of the state. And these were not Telugu speakers. So, as a special case, the Mulki rules were adopted and ratified by Parliament, and it says that there would be some reservation for those with this. So there are things written about it in that historical time, not so much acknowledged in the legal discourse. If you're interested, you can read further. Okay, dissent. Why is dissent there?
Ma'am, I think that it was to discontinue with the practice of hereditary offices, like that of the office of the village headman, as was under Tamil Nadu Hereditary Village Offices Act.
Very good. As well as the office of priests in any temples that are taken over by the state, for example. So, because there has been a tradition that the son of the son will go, so to prevent dissent, and that dissent is clarified a little further if you look at Article 16.5. Nothing in this article shall affect the operation of any law. So 16.5 is an exception to 16.2. Look at 16.5. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person belonging to a particular religion or belonging to a particular denomination. So this 16.5 is talking about religion, not about descent, religion. State should not discriminate only on the basis of religion. But suppose the government takes over a temple, and it can take over certain temples. When I come to Article 25 and you look at Article 25.2, that kind of takeover is possible. So let's take the Travancore Devaswam Board, which is a big temple which has been taken over. Now, all people who belong to or can get employment in that temple will become state employees. Now, if we were to use denomination, then people who are performing puja there may not belong to the religion or that denomination. And the religion, of course, is the larger body. The denomination will be the subsect of it. So, for example, the denomination of Anandamari, the denomination of Digambar Jain. These would all be denominations. So, merely restricting certain bodies, look at 16.5, to a member of the governing body or to an can be restricted that only a Hindu can be appointed as the chairman of the Travancore Devaswam board, because you don't want some non-Hindu to be running that particular temple. So 16.5 is in that sense an exception to 16.2, which is dealing with religion. Therefore, looking at the focus of the article, we've tried to see why, when we're dealing with public employment, there are those additional grounds of residence, of place of birth, and when it comes to admission to state-run educational institutions or state-supported, we've seen that because of the reality that there are women-only institutions, sex gets dropped. Because there is a reality that admissions is difficult to come by, and if the state government is funding an institution, it may wish for reservation on what I'm loosely calling domicile basis. Therefore, residence is not a ground under Article 29.2. So 16.2 is specific, 29.2 is specific, but the generic one for all other areas is Article 15.1. Now it says on the grounds only. Now, when it says on the grounds only, what it means is that that ground has to be either solely religion or race or caste, or it can be a combination of those five that are mentioned there. However, suppose I was to have a discrimination on the grounds of sex along with something else, then that kind of intersectionality will not fall foul of Article 15.1. So let me take an example to explain this to you. Okay, and I'm going to be looking at the adultery cases to explain why this is not the only way. So in the earlier case, okay, I think maybe what I would do is I'll give you the chance to read Joseph Shine, which is the discussion on adultery, before I take up this example of only some more with adultery. But I'll go back to my Air India example of Nargish Mirza to explain the word only again. Or I'll explain both, and you can read Joseph Shine, which is the constitutional bench, striking down 497. Did you study Joseph Shine in first year?
No, ma'am. No, ma'am.
Now, let's go back to the Air India case of Nargish Mirza. These women who are air hostesses are getting retired at age 35, whereas the corresponding male who is the flight purser is allowed to continue in office till age 58. Now, if you look at Justice Fazl Ali's judgment in this case, Justice Fazl Ali's judgment, what you will notice is that he makes the point that this is not discrimination, it is not hit by Article 15. The reason being that women air hostesses make a separate cadre of recruitment with different terms and conditions of employment, and flight pursers, who are all men, are a different cadre of employment. So there is no discrimination between air hostesses on the one hand and flight pursers on the other. And reading between the lines, what you could then conclude is that the reason women are being retired at 35 to ground duty, whereas their male counterparts continue to fly and work in the skies till 58, is because not only on the grounds of sex, but also because they happen to belong to two different cadres, two different feeder channels that are supplying or being recruited for to Air India. And therefore, the discrimination is not only on the grounds of sex, it is on the grounds of sex and their cadre. And that cadre, CADRE, meaning that separate recruitment for that line of promotional avenue of cadre. So, because of that, and all that 15.1 requires is that you should not be discriminated only on the grounds of sex. But here the court found it was sex and recruitment. The initial recruitment was on two cadres. Starting salaries were slightly different. Their avenues for promotion were slightly different, even though on the plane they were essentially doing the same job. Because their cadres were different, the court took the view that they were treated differently on grounds of sex and something else. And the prohibition in 15.1 is that you should not be discriminated only on the grounds of sex, which means that you could conclude that if you were smart enough to include two grounds of discrimination, sex and something else, and that and something else should not be another prohibited ground in 15.1. So it shouldn't be sex and race, it shouldn't be sex and religion. That type of intersectionality is ruled out in 15.1. But sex and age, sex and, because age is not a prohibited ground, sex and sexual orientation, sex and the kinds of clothes that you wear would not be a prohibition or hit by Article 15.1, because the word only means that the grounds of prohibited discrimination are confined to those 5 heads taken either singly or together, but nothing else. Okay. Therefore, Nargish Mirza. Now, Joseph Shine is, of course, a very important judgment because, speaking through Justice Chandrachud, Section 497 of the Indian Penal Code gets struck down. So I'm going to defer Joseph Shine till you have the chance to read it, but I'm going to come back to yet another example of Article 15.1 to show what it means to have discrimination only on the ground, let us say this time, of sex. Operation Polo, I didn't understand. What is that? Ravi Lal, why have we written Polo? I don't know.
You are talking about the annexation of Hyderabad.
Okay.
This is on a mission name run by the Indian government.
Right. Where they did the sorties, flew the sorties. Like they flew the sorties into Kashmir, right? The enormous number of sorties that were flown in October 47. Yes. Yeah. There's a very good account of that sorties by our, very senior journalist. Lovely book it is on the Kashmir and the sorties that they flew. Okay, no, let me not get diverted. I had discussed the is that so? It's news to me.
Yes, ma'am.
Akshay, is that so? But is it on
Yes, ma'am.
paper? Is it on paper?
Yes, ma'am.
6 judges and
There's also a case on Gaurav Yadav versus Union of India.
I see. And please enlighten me.
Nothing
I'm not sure. Okay.
But nothing is happening. So Supreme Court said that army has her own process.
Is that so? Okay. Because
Yes,
we
ma'am.
also have Babita Punia versus Union of India, where on the grounds of sex, not allowing women into the armed forces, has been struck down both in the army and in the air force, etc. Babita Punia versus Union of India. Judgment of Justice Chandrachud delivered recently, a couple of years ago. But let me take Anuj Garg first on the grounds of only sex. Okay, let me take up a couple of cases. I'll look at this Gaurav Yadav and look at it. I'm just noting it down. I don't think I've read that judgment. Okay, now, but in those of you who are interested, you can look at this judgment, Babita Punia, which is on another army case, but dealing with recruitment of women and is it permitted or is it not. So this is a judgment that came out in 2019 or 20, and it deals with this form of discrimination. And there the court was not willing to say that this is a question only of women. So you can look at that. I'm taking up another case, which is Anuj Garg versus Union of India. And this is dealing with the question of whether women can work in bars and hotels. And the rules of the Punjab excise rules, which extend to Delhi, indicate that no woman can serve in a hotel, be employed in a hotel which serves liquor, because somehow it will be detrimental to the morals of women if they were to be bartenders. This challenge went all the way up to Supreme Court, and this Anuj Garg case of 2008 is an interesting case. If you're interested, you should read it. You just do Indian Kanun, you'll get it. There's a very good judgment of Justice Sinha, and what is interesting in it is that he says that this is discrimination one only on the grounds of sex. And more interestingly to us, he says that this is not saved by Article 15.3. So there is a good judgment of the Delhi High Court, and then it goes in appeal to the Supreme Court, and Supreme Court takes slightly different grounds but comes to the same decision. But because we are all law students, we are also interested in the reasoning. I'm going to put this reasoning to you, and I'd like to hear your reaction to it. Women cannot be appointed as bartenders because women should not be serving liquor, and the rule is justified by the Union of India on the grounds of 15.3. 15.3, okay. Ravi, I'll look at that. Thank you. Just remind me, I must copy it before I close the classroom. Otherwise, I lose all your URLs. Okay. Now, the point is that the Union of India said, look at Article 15.3 and just turn to 15.3 for a moment. It says, nothing in this article shall prevent the state from making any special provisions for women and children. The state can open a woman's only college. Okay, for at this time, and let me go out on a limb and say what I'm going to say. I've said it before also. If you look at Delhi University, we have some 70 colleges, and at least some 25 to 30 are women's colleges. So it's relatively easier for a woman to get admission into Delhi University compared to a man. It's a fact. It's truly a fact. Of course, women do better than men in school exams. That is also a fact. It is a fact that women outperform men. So because on merit, certainly those women are up there on top and they are getting admitted. But there's also another factor. 100% of the seats in these 25-30 women's colleges are reserved only for women. So it's easier for a woman who is not perhaps academically got such good results to get admission into some college compared to a man. Is this discrimination on the grounds only of sex? The women's only colleges are saved by Article 15.3. So what the government argued was to not have women serving liquor in bars is because we want to protect women. This is the same as the bar dancing cases that have come to us repeatedly from Bombay. There have at least been 3 rounds of litigation of bar dancing, where women dance in bars where liquor is served. And every few years, the Bombay government will prohibit dancing in these bars where liquor is served and where poorer people generally tend to go, but will not prohibit women dancing in high class cabarets in 5-star hotels where liquor is served. So, on this point, it has been challenged both under Article 14 that it's a wrong classification, because if women can dance in these 5-star hotels, why can they not dance where the Aam Janta goes? That's one, that's a 14 ground. But the 15th ground has been, why do you want to deny us in the name of protection? Why do you want to deny us our rights to employment? And every time the litigation has come to the Supreme Court, more or less the same arguments have been made. That is, we are the only breadwinners for our family, and if you outright prohibit us, or you prohibit us indirectly. And how is that prohibition done indirectly? Because the Bombay government has done 2 ways. One, it directly bans women dancing in these bars, certain types of bars. Or the second is to say, under the Shops and Establishment Act, no women can be employed after 9:30 or 10. So indirectly, you prevent the employment of women. One of the 2 ways is the way they have used it. And the argument of these bar dancers has been that, look, it's for us, it's employment. So we don't need this protection where we are left without only discrimination. So this is not protection, this is discrimination. So one way of looking at Article 15.3 is to look at it, making special provisions for women and children is to view it as a power to the state to protect. But another way to look at it is that actually the government is discriminating against women and children when in the name of protection. So all the pinjara toads, all the bar dancing, all the employment of women as bartenders will come into play. So Anuj Garg is dealing with bar tending. The cases dealing with bar dancing are dealing with bar dancing. Okay. Now, why I would advise you to read the judgment in Anuj Garg is, I find that it's a very good judgment, because the judge says when protection ends and when discrimination starts is not a legal question. It's a question that has to be determined, and society has to determine when this protection ends and when discrimination begins. And as we progress and we go further and further, and more women get drawn into employment, to suddenly say that they cannot serve liquor. And in the liquor case, because after the age of 25, anybody can drink liquor in a bar in Delhi. So if you are able to drink liquor but you cannot serve liquor, this doesn't make sense. And then they're actually, it's quite interesting, the judgment, because they say, how come air hostesses, Air India, when it flies, it recruits girls as young as 18 and 19, and they serve liquor on flights going abroad. So what they can do 30,000 feet above the ground, why can they not do it on the ground itself? Okay, Sakshi, time is up. So we end here, and we will continue tomorrow. Okay, let me.
Thank you, ma'am.
Yeah, thank you, Sakshi. I'd really appreciate if you were to tell me 5 minutes before. Okay.
It doesn't feel good interrupting you, but
Yeah, but it doesn't matter. I have to be interrupted.